Assalamualaikum warahmatullahi wabarakatuh. My name is NAZIRA binti AHADI and I'm gonna talk about Murabahah. The definition of Murabahah. As we know, Islamic banking has significantly developed in recent years, and due to the prohibition in Islamic banking system, contrary to the conventional banking system, some of the tools were discovered by Islamic banking practitioners. And Murabahah is one of the most popular Islamic financial tools, particularly in terms of house financing. Okay, the definition of murabahah in the term of Arabic language was derived from the Arabic root word which is rabiha, which means to grow in business and succeed. Making profit is the measurement of the success. Therefore, the generic term murabahah is often linked to the declaration of the profit as a way of measuring the success of the sale transaction and the return of the exchange of money with commodity. In the classical Arabic dictionaries, murabahah is often used to describe the sales transaction where the profit amount is known and declared. For example, when the traders say, I will sell you this commodity with a profit of 1 dirham for every 10 dirham. Murabahah also defined as a type of cost-plus agreement between a client and an Islamic financial institution, which is IFI. The IFI purchases a good from the third party and then sell it to the client with a fixed markup profit. For examples, if a seller agrees with his purchaser to provide him from specific commodity on a certain profit added to his cost, it is called as a murabahah transaction. And the basic ingredient of murabahah is that the seller discloses the actual cost he has incurred in acquiring the commodity and then adds some profit therein. And this profit may be in lump sum and may be based on the percentage. And originally, murabahah was kind of a sale agreement rather than financial instrument. The client who wants to buy a house must apply to the IFI and then the IFI purchase the house from the property owner. After the transaction, the bank sell the house at a markup price to the client, and after the IFI purchase the house, the client will have two options. First option is purchase the house from the bank immediately, and second option is he can buy the property on deferred payment. And as time goes by, the need and demand for Sharia complement product emerge, particularly from the Muslim customer, as they are not allowed to practice riba. Notwithstanding the above, given the high price of some assets, customer could not afford to pay full in cash. Subsequently, give rise to the need to make a payment via installment. And in such situation, the sale price is deferred to some time in the future and to be settled by the way of installment according to an agreed payment schedule normally typed up with the individual or entity source of income. Besides, the expert in Sharia trying to find way to accommodate this situation as a result innovation in financing product. Murabahah was later identified as one of the concepts to resolve the matter. This is the time when Murabahah, apart from the traditional view of trading activities, and is considered as a method of financing in the modern world. Besides, pursuant to Sharia rules, a sale can be valid under circumstances. First of all, sale agreements cannot be valid unless the subject of the sale exists during the sale. Secondly, the seller must have the possession of the subject at the time of the sale. Thirdly, the sale should be certain. And fourth, the subject should be value. Fifth, the subject of the sale should be not prohibited by Islam or haram. And finally, the price should be certain. As a financing term, Murabahah transaction must meet some condition in order to be valid with regard to Sharia. Murabahah does not include interest and it depends on cost plus profit. In Murabahah transaction, IFIs does not provide a loan to client. In fact, they only sell the property to consumer with markup price. The IFI must have the ownership of the property at the time of the sale, and in practice, IFIs give permission to clients, being their agent and client, buy the property on the IFI behalf. During the time, client act as a trustee. When the bank sells the property to the client, the trustee relationship finalized and the ownership of the property transferred to the customer.
Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is FATINI binti Muhammad FADZIL, and today I will present the application of Murabahah. Murabahah is one of the new alternatives introduced in Islamic banking in Malaysia to replace other instruments. It is also the most commonly used method of financing used by whole world Islamic banks. It could be used to finance the purchase of assets in a variety of forms and wherever assets are needed to be purchased from a third party. There are three types of application of Murabahah. First, retail banking. Two, international trade. Three, investment banking. Retail banking is a banking that provides financial service to consumer as individual, not business. The form of Murabahah practice in Sharia banks is based on Murabahah lil Amir Bishira. It is Murabahah to the purchase order concept. Murabahah to the purchase order concept is a sale and purchase transaction where the customers come to the bank to buy goods with certain specification. Then the bank promises to buy the goods as intended, and the customer promises to buy the goods mentioned in the Murabahah contract in accordance with the base price of the purchase, plus the level of profit agreed upon by both parties. And the customer will make payment in installments according to financial ability. Three parties who involved in this contract are: first, the party who gave the order to buy the goods, which is customer. Second, the banks and the seller. Retail banking is used for assets like car, house, and others. There are three issues in Murabahah. First, banks and customer promise each other to buy and sell the item. When the customer apply for the financing of goods to the bank with specific specification, they will make an agreement, which is the bank will promise to sell the item to the customer, and the customer will promise to buy the item with an additional profit on the cost of the item purchased. Second, the penalties for late payment of Murabahah debt. It is permissible to have an undertaking from the customer to pay an amount of percentage of the debt to be donated to charitable causes in event of delay in payment or installment. Lastly, rebate if debts are settled early. Rebate on early payments happen when the customer makes an early payment and there is no commitment from the institution in respect of any discount in the price of Murabahah. Then the institution has the sole discretion in allowing them the rebate. Next is international trade, also known as letter of credit or LCI. International trade is a written undertaking by a bank given to a seller at the request and on the instruction of the buyer to pay at sight or at a determinable future date up to a stated sum of money within a prescribed time limit and against stipulated documents which are in compliance with the term and condition of the LCI. For export or import financing in Islamic banks, LCI are not treated as a guarantee but rather as a fee-based banking service to facilitate trade. There are two types of LCI offered by the bank based on different Sharia concepts. First, LCI of Wakalah. It is LCI without financing and fully cashback, and upon payment, the bank will set off the deposit placed by customer during issuance of LCI. Second, LCI of Murabahah. LCI of Murabahah is the LCI with and without financing. Upon payment of LCI, customer has the option either to request for financing or utilize their own funds to effect payment. Lastly is investment banking or Sukuk Murabahah. Sukuk are certificates of equal value representing undivided shares in ownership of tangible assets, usufruct and services. In Murabahah Sukuk, the issuer of certificate is the seller of the Murabahah commodity. The subscriber are the buyer of the commodity and the realized funds are the purchasing costs of commodity. The certificates holder own the Murabahah commodity and are entitled to its sale price. That's all from me. Bye.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is LUTFATUL HAKIMAH BINTI SHAHRIL ANWAR, and today I would like to present on the topic Sukuk Murabahah. What are sukuk? Sukuk means certificates. Islamic securities are popularly known as sukuk, which plural of suk. Sukuk refers to an Islamic investment certificate which allows investors to have right of ownership of the asset, including the cash flow and risk associated with such ownership, which it is also similar to trust certificate which represent a share in an asset of a business venture. Next, Sukuk Murabahah. Any paper representing a monetary obligation arising out of a credit sale transaction by banks cannot create a negotiable instrument. Murabahah receivables cannot fetch any return and their assignment has to be at face value. Murabahah sukuk are more likely to be used in respect of purchases of goods by the public sector. In case the government needs items of huge price, it may purchase them through credit sale by paying in installments. The government will issue certificates according to the number of installments. Each certificate having maturity date would represent property right of the seller that can change hands provided amount of the claim does not change. The seller or the original certificate holder can transfer his collection right to another party against payment that will be equal to the face value of the certificate minus collection costs at the transferee's end. Any Murabahah funds can also issue Murabahah Sukuk proceeds, of which could be used for sale of pre-specified and general assets on the basis of Murabahah to give quasi-fixed return to the Murabahah Sukuk holders. Other opinion regarding tradability of Murabahah Sukuk. It is not permissible to trade in Murabahah certificates after delivery of the Murabahah commodity to the buyer. However, trading of Murabahah certificates is permissible after purchasing the Murabahah commodity and before selling it to the buyer. Modus operandi of Sukuk Murabahah. It begins when the obligator wants a commodity or assets and start a business but it has no capital. So, the obligator meets with SPV to make a loan. SPV agree to give Sukuk certificate. And after that, SPV will issue and advertise the Sukuk certificate to find an investor. The investor who wants to buy Sukuk certificate will give a sum of money to SPV and the Sukuk certificate will give to them. Number 2. SPV will use the money to buy an asset or commodity from the suppliers. Number 3. Supplier will deliver the asset or commodity to the obligator. Meanwhile, the purchase document will be submitted to the SPV. Number 4. Obligator will pay the cost plus profit margin to the SPV by direct finish payment or defer payment before the maturity date. And lastly, SPV will predict distribution of defer payment to the investor. And that concludes all the modus operandi of Sukuk in Sukuk Murabahah. Other categories of Islamic Sukuk transaction. Number 1, Sukuk al-Murabahah. Number 2, Istisna Sukuk. Number 3, Salam Sukuk. Number 4, Mudarabah Sukuk. And number 5, Musyarakah Sukuk.
Assalamualaikum and hi, my name is IZARATUL AFIFAH binti JAMALLUDDin. So next, I want to present about the difference between Sukuk and conventional bonds. So there are 5 aspects the difference between the Sukuk and conventional bonds. First, definition. Second, asset ownership. Third, price. 4, principles. And 5, return. So, the aspect difference between Sukuk and conventional bonds is in terms of definition. So, the definition of Sukuk is the Sukuk can be defined as a fixed income certificate that represents an ownership of underlying assets, services, or investment. Second, Accounting and Auditing Organization for Islamic Financial Institutions, or AAOFI, defines Sukuk as being certificates of equal value representing undivided shares in the ownership of assets and services or in the ownership of the assets of particular projects or special investment activities. And then, definition of conventional bonds in terms of language is a letter of evidence of debt or loan. Second, the conventional terms are debt instruments that require issuers, known as borrowers, to pay to creditors, known to investors, a total amount borrowed by plus interest at a certain period. The second aspect is asset ownership. Sukuk indicate ownership of an asset. Sukuk holders own part of the underlying assets in any sukuk transaction. Second, this is depending on the extent of their investment, which determines the share they are entitled to. On the other hand, conventional bonds indicate a debt obligation, but not indicate ownership of an asset. Second, the nature of conventional bonds does not allow such type of ownership, since the securities are considered debt obligations. These conventional bonds creditor instead of the owner, and they have no rights to void for against acquisitions and assets of the company. So obviously that the sukuk represent a share in the ownership of asset, business or joint venture, but the conventional bonds merely represent a share in the total debt, but not in the ownership of the asset. So let's go to the next aspect. The third aspect is price. Sukuk is more stable as it is based on certain asset, business or projects. The issuance price of sukuk is based on the market price of an asset or a project. Sukuk are priced according to the value of the assets backing them. So for conventional bonds are not based on asset. Conventional bonds are unstable because the price is more elastic and easily experience drastic declines and increase. The issue price for the conventional bonds is based on the value set by the bond issuer. Bond pricing is based to credit rating. So it is clear that the price for this sukuk is more valuable than conventional bonds. So, what is the next aspect? The next aspect is principles. Principle is the most important difference between sukuk and conventional bonds. Sukuk, the principles used by sukuk are based on Sharia principles and are valid in terms of Islamic law. Sukuk issuers are subject to Sharia regulations. For example, sukuk must be used for Sharia compliant purpose. How about the conventional bonds? The bond issuance is not subject to Sharia compliant purpose and include products or services that are against Islam, not based on Sharia principles, which involve the elements of usury, uncertainty, gambling, and other prohibited elements. Although it is legal in terms of national and financial laws, but it is illegal in terms of Sharia compliance. The last aspect is return. Sukuk. The return for sukuk is based on the performance of the assets or projects owned by the investor. Repayment for sukuk is by income derived from assets, service, and investment based on contractual commitment. The conventional bonds. The return on conventional bonds is a predetermined benefit and is not associated with the performance of any asset or investment. The repayment for conventional bonds is based on periodic cash flows and the amount that has been set. So, the conclusion is there are 5 aspects the difference between sukuk and conventional bonds. So, that's all for me. Thank you.